For one final confirmation, TL01, your speakers will be taking 21 minutes and 23 minutes respectively. Yes?
Yes.
TL08, both your speakers will be taking 21 minutes each. Yes?
Yes.
Thank you.
Thank you.
Participants, the round might begin sooner than expected, so kindly prepare yourselves.
Anisa and Malavika, the judges would join at 9:50. So they just left the briefing session.
Noted, sir. Participants, when we call your names out, you could do a bow or a wave so the judges are acquainted with you.
Okay.
If the judges permit, may we begin?
Yeah, sure.
A pleasant morning to one and all. I welcome you to the final round of third Surana and CUSAT School of Legal Studies Dr.AT Markose Memorial Technology Law Moot Court Competition 2022. It is our esteemed privilege to have with us as judges Honorable Justice Kausar Erapagat, Judge High Court of Kerala, Honorable Justice Viju Abraham, Judge High Court of Kerala, and Advocate N. Suri Senthil, Head of Intellectual Property Litigation, Media and Technology Law Practice at Surana and Surana International Attorneys. Thank you, judges, for being with us today. I'm Anisa, and I'll be your floor manager. Malavika and Nimya will be your court officers. For the kind attention of the judges, we have here team code TL01 for petitioner and TL08 for respondent. Counsels for the petitioner are TL01, Speaker 1, Anas, Speaker 2, Dhruva, and Researcher, Tisha. Speaker 1 and 2 would be taking 21 minutes and 23 minutes respectively, while reserving 1 minute for rebuttal. Counsels for the respondent are TL08, Speaker 1, Surya, Speaker 2, Sriharini, and Researcher, Shakti. Speaker 1 and 2 would be taking 21 minutes each, while reserving 3 minutes for rebuttal. If the judges permit, I'd like to invite TL01, Speaker 1, counsels for the petitioner to commence the oral round.
Okay, you can start, Anas.
Okay. Before I begin, I'd just like to confirm, am I audible and visible?
Yes. Very much.
May it please the Honorable Court, I am Counsel TL1 appearing on the behalf of petitioners. The Counsel seek permission to collectively address the bench as your Lordship. Much obliged, your Lordship. The Counsel seeks permission to state the jurisdiction of the case.
Yes.
Much obliged, your Lordship. It is humbly submitted before the Honorable Supreme Court of Aharat that by the power vested in it, by the virtue of Article 136 of the Constitution of Aharat, it has the inherent jurisdiction to hear, adjudicate, and dispose of the incident matter. The Counsel seeks permission to state the statement of facts.
Yes.
Much obliged, your Lordship. Republic of Aharat, island country in the Indian Ocean. It adopts the Constitution and laws of India. Muskla is a cutting-edge technology company specializing in e-mobility based out of Silicon Valley in the USA. Muskla's CEO and founder is Elon Musk. Muskla intends to launch its electric car M in the Republic of Aharat, which deploys autopilot technology on level 4 high driving automation. However, the Ministry of Road and Transport did not issue any approval to use the autopilot technology in Aharat. Therefore, the M was launched without the autopilot technology. While a driver could purchase the car from Muskla Aharat, they entered into an end-user license agreement with Muskla Incorporated, which governed all online services and use of firmware. Muskla Incorporated disclaimed any liability from autopilot use. Kim Virsinga is a social media influencer based in Aharat. In the early morning of 1st March 2022, Kim hacked to get the access to the autopilot mode while on her way to work. She experimented and used an adhesive on heavy gloves and placed them over the steering wheels of M. She could hack M to think that she had put her hand on the wheel. Within 10 minutes of this, Kim's car met with an accident. A lorry in front of Kim's M braked suddenly, and to avoid collision, Kim's M suddenly applied its brake. M was under the impression that Kim was holding the steering wheel. It waited for a few milliseconds for Kim's input on whether to turn the steering wheel to the right or left. After no response, M stirred right to avoid the collision with the school and rammed into a shop, killing 2 people. The council seeks permission to state the issues.
Sure.
Much obliged, your Lord. Issue 1 is whether the government of Aharat's ban order prohibiting M firmware or M's app to access its servers maintained by Muskla Incorporated by connecting to the internet within Aharat is valid under Section 69A of the IT Act. Issue 2 is whether the Muskla Incorporated and Muskla Aharat can be termed as intermediaries under the Section 79 of the IT Act. Issue 3 is whether the Muskla Incorporated and Muskla Aharat can claim any immunity from prosecution under the Penal Code and the Motor Vehicle Act. Issue 4 is if the above issue is answered positively, then can Dusk and Dhanraj also claim immunity from prosecution given that they are just officers of Muskla Incorporated and Muskla Aharat? Your Lordships, issue number 1 and 2 will be dealt by the Council, whereas issue number 3 and 4 will be dealt by my co-counsel.
Right.
The Council seeks permission to proceed with the arguments for issue number 1.
Right.
Much obliged, Your Lordships. Issue 1 is whether the governments of Aharat's ban order prohibiting M firmware or M's app to access its servers maintained by Muskla Incorporated by connecting to the internet within Aharat is valid under Section 69A of the IT Act. Your Lordship, the contention of the Council is that Aharat's ban order prohibiting M firmware or M's app to access its servers maintained by Muskla Incorporated by connecting to the internet within Aharat is invalid under Section 69A of the IT Act. The Council will be dealing with this issue in a threefold manner. Firstly, the ban on the M app is arbitrary. Secondly, the ban was not in accordance with the Information Technology Rules 2009. Lastly, the Council contends on the principle of audi alteram partem. Your Lordship.
Yes.
Your Lordship, dealing with the first fold, Section 69A of the Information Technology Act 2000, in subsection 1, states the ground on which an app could be banned, which are in the interests of sovereignty and integrity of Aharat, defense of Aharat, security of state, friendly relations with foreign state, or public order, or for preventing incitement to the commission of any cognizable offense relating to the above. And it also makes it mandatory for the central government or any of its officers, specially authorized by it in this behalf, after they are satisfied that it is necessary or expedient to do so on the above mentioned ground, to record the reasons in writing for banning the app. Your Lordship, it is the contention of the Council that the EMS app does not affect the sovereignty and integrity of Aharat, defense of Aharat, security of Aharat, its friendly relations with foreign state or public order, or inside the commission of any cognizable offense, and it is arbitrary to ban and make 40,000 EMS plowing the street of Aharat futile. The app is just used to authenticate the user's credential online, as stated in the fact sheet on the page 4, paragraph 1, in line 5.
See, Council, Section 69A empowers the government to impose ban on the app also in order to achieve the interest of public order or preventing the incitement to the commission of any cognizable offense relating to the public order. So the ban is found to be necessary to prevent the company from causing any serious offense. So is it not in the interest of public order to attract Section 69A?
Your Lordship, firstly, there was no reason given by the government when the ban was imposed. And secondly, Your Lordship, there is no...
So if it is in the interest of public order, it falls within Section 69A. Then it is perfectly valid.
Indeed, Your Lordship, for banning an app, the reasons are to be recorded in writing, and Your Lordship,
that's your second point. It's not recorded and no notice, no. It violates audi alteram partem principle. So far as your argument is concerned, it doesn't fall within the four walls of Section 69A. If it is in the interest of the public order as well, the ban is well founded.
Your Lordship, there is no proof as to how it could lead to disruption in public order.
I'll add to that. A report says 40,000 models are sold so far in the country, and 70% is using autopilot. So naturally, the government can take an action under public order, which includes public safety. What is your answer on that?
Indeed, Your Lordship, the report is from the newspaper It was an Aharat Times newspaper report, which is inadmissible in a court of law, Your Lordship. It is merely hearsay evidence. The Council will be dealing with this issue in brief in issue number 2.
How can you say that it is an hearsay order? It is on facts that an accident has taken place and 2 citizens were killed in that accident. And there is report that, as Brother Justice Viju said, 40,000 out of 40,000 car, there is evidence to show that 70% of them use vulnerability.
It's hacked.
Indeed, Your Lordship, the said report was done by Aharat Times newspaper, which is inadmissible in a court of law because it is considered as hearsay evidence as established by the Honorable Supreme Court in previous cases.
Yes.
Your Lordship, the incident which took place with Miss Kim, it was because the car was not equipped to use autopilot technology. It was launched in Bharat without the autopilot technology, and Miss Kim went on to make it in level 4 automation technology to a level 5 automation technology. If your lordship are satisfied, the council seeks permission to continue.
Yes.
Right.
Much obliged, Lord. The Lordship Council also contended that there was no reason given by the government on why the M app was banned. It is required under the Information Technology Act in writing, and only when the central government or any of its officers, especially authorized in its behalf, are satisfied that it is necessary or expedient to do so. Therefore, Your Lordship, the Council humbly contends that it was arbitrary to ban the app without giving any of the above mentioned reason. Your Lordship, coming to the second full of the argument, the Council contends that the ban was not in accordance with the Information Technology Rules 2009. According to 69A, subsection 2 of the Information Technology Act 2000, the procedure and safeguard subject to which such blocking for access by the public may be carried out shall be such as may be prescribed. The procedure and safeguard are prescribed in the IT Rules 2009, Your Lordship. Your Lordship, the blocking order provides for a detailed from receipt of a complaint in writing to setting up a committee for examination of request, the issuance of a show cause notice to the content creator and intermediary until the final stage of issuing an order directing the blocking of the offending information. The only exception to the adherence to this detailed procedure is in the case of emergency, when a blocking order can be imposed expeditiously on receipt of a complaint. In instance of an emergency, blocking order must be brought before a committee for consideration not later than 48 hours of
Is
issuing.
it not a case of emergency?
Indeed, not, Your Lordship.
Because I've already stated 70% of the car made use of this vulnerability, and due to this vulnerability, an accident took place, causing death of 2 citizens. So is it not a case of emergency?
Your Lordship, the newspaper report of Bharat Times claiming that 70% of the car have used autopilot technology is not admissible, Your Lordship. It cannot be established that what they are saying is true.
So it's the fact that accident has taken place and 2 persons died in the accident.
Your Lordship,
It's not a case of emergency.
Your Lordship, it is an isolated incident where the Kim, who went beyond the scope of services offered by the company, went on, hacked it, and then took it a level higher by making it a level 5 automation instead of a level 4 where the driver is required to keep their hands on the steering wheels.
Is it not your duty to, your company's duty to have a mechanism whereby if there is someone violating or hacking into a system, what is the mechanism in place to counter it? Otherwise, you will be held responsible for that.
Indeed, Your Lordship, there is an end-user license agreement where if a person who hacks such a system, their account will be banned.
Have you done with respect to the other 39,900 users who are hacked as per the website? What is your answer for that?
Could Your Lordship please repeat the council?
There are around 40,000 cars running. Only one car has met with an accident. There is a possibility that the other remaining cars, what is the action taken by you so that the government will not interfere in that if you have taken some action on your own?
Your Lordship, the company has been due diligence and has been fixing its vulnerability as soon as possible. The first vulnerability was fixed within the 6 months of time, and the next vulnerability was fixed within 10 days. Your Lordship, the action undertaken under the blocking rules must be based on a complaint received in writing. Your Lordship, there was no complaint against the M app. Your Lordship, Indian court offered an approach where the state action must satisfy the condition of backing of a law, legitimacy of purpose, rational connection of act and the object, necessity of action, and the test of proportionality. Your Lordship, it is the contention of the council that the legality of the app must be adjudicated against the aforesaid backdrop. If the banned app is a threat to the security of the country, the government will have to put our complete ban on the app without an opportunity of hearing the most reasonable approach. Your Lordship, in Anuradha Basin versus Union of India, the Supreme Court opined that the degree of restriction must be in consonance with what is actually necessary to combat an emergent situation. It is the contention of the Council that the ban fails the test of proportionality, as due to one user who went beyond the services of hacked the system and used the auto-edit feature. When it is explicitly mentioned, it is banned in Bharat and disabled. It is a contention of the council that the ban is the best of necessity for action, since the company is working hard day and night to fix the vulnerability. And such a strong measure is rather arbitrary. The Lordship,
What is the prejudice caused you if the ban is continuing until you fix the entire issue?
Your Lordship, the vulnerability is fixed within the 10 days of it. The company has fixed the vulnerability. Your Lordship, lastly, the council contends audio alternate part. Your Lordship, the ban on the M app was done without even giving a chance to be heard, which is one of the basic principles of natural justice. This is a very strong rule which holds that no one will be judged without a fair hearing.
Yes.
The council believes, under the watchful eye of the court, that both the parties are equivalent and have equivalent chance to speak and to prove themselves. As the same was held in Urban Lal versus Commissioner, National Cooperative Bank versus Ajay Kumar, and Fateh Singh versus State of Rajasthan. The M was banned without giving any reasons. The parties were not even given a chance to give their view. Therefore, it is humbly contended for this honorable court that Bharat's ban order prohibiting M firmware or M's app to access its servers maintained by Muscla Incorporated by connecting to the internet with Bharat is invalid under Section 69A of the IT Act.
Yes.
Therefore, it is humbly submitted before the honorable court that the orders in question are manifestly arbitrary and procedurally and substantially not in accordance with Section 69A of the IT Act. Further, fail to comply with the procedure and safeguard prescribed by the Information Technology Rule 2009.
Yes.
If your lordships are satisfied with the argument, the council seeks permission to proceed to the next issue.
One thing more. See, you have directly challenged the order before this court. Yes. An order passed under Section 69A, which is passed should have been passed following the procedures contemplated in the rules of 2009. See Rule 14. Rule 14 deals with the review committee for reviewing any order passed under Section 69A. So you have directly come to this court without approaching the review committee as contemplated under Rule 14. When you have an effective alternative remedy, how can you directly approach this court without availing that?
Indeed, your lordship, under the Rule 14, there is a Rule 14. It is given that meeting of a review committee.
Yes.
That review committee should meet at least once in 2 months and record its finding whether the direction issued under these rules are in accordance with the provision of subsection 1 of Section 69A of the Act. Your lordship, it is a contention of the council. There was no reason given, and there is no reason which is mentioned in Section 69A clause 1 that is being violated. Also, your lordship, the review committee should meet once every 2 months to review if the ban is valid or not. Your lordship, the ban was placed on 15th March 2022, and we are approaching the Supreme Court of Bharat in October 2022. Your lordship, there has been no mention of setting up of a review committee. Your lordship, you're on mute.
We will direct the review committee to hear you immediately.
Yes.
Your lordship,
We will direct the review committee to hear you.
Which are the circumstances at which you could directly approach this court without availing the alternative remedy available to you under Rule 14? Which are the circumstances under which you could approach this court? What is special in this case for you not to approach the review committee or the alternative remedy available and directly approach this court?
your lordship, the council have approached the High Court and their petition was quashed.
High Court is for quashing the criminal proceedings.
Indeed, your lordship.
Challenging the order under 69A. A review committee or an alternative remedy is provided. What is the special circumstances under which you could approach directly this court without availing the alternative remedy? What does the Supreme Court say on this point?
Your lordship, 40,000 M's running in Bharat are made futile without giving any reason. That's why we have approached the Honorable Supreme Court for a chance to be heard.
Yes. Yes, you can continue.
Much obliged, your lordship. Issue 2 is whether Muskla Incorporated and Muskla Aharat can be termed as intermediary under Section 79 of the IT Act. The Council for Petitioners humbly contend that Muskla Incorporated and Muskla Aharat can be termed as intermediary under Section 79 of the IT Act and hence can be exempted from liability. The Council will be dealing with the issue in a threefold manner. Firstly, by proving how they are intermediary. Secondly, there exists no actual knowledge and due diligence was adhered to. Lastly, the newspaper report is inadmissible in a court of law. Your Lordship, dealing with the first fold of the argument, the term intermediary is defined in Section 2W of the Information Technology Act 2000. Intermediary, with respect to any particular electronic records, means any person who, on behalf of another person, receives, stores, or transmits that record or provide any service with respect to that record. Your Lordship, Council humbly contends that Muskla Incorporated and Muskla Aharat act as a facilitator of information between the car driver and the service centers and charging points. When the vehicle driver switches on the vehicle, he initiates the transmission, and then the nearest service center becomes the receiver of the transmission. Muskla in no way modify the information contained in the transmission. It is humbly contended that Muskla's Operation Aharat are still at an incipient stage. Despite Muskla Aharat nebulous and limited infrastructure, Muskla Incorporated and Muskla Aharat are committed to provide the best service to the customers. In order to achieve world-class services, Muskla tie up with third-party dealers and service centers like all the other companies. Furthermore, these third-party customer centers and dealership communicate to the customer through the console system in the automobile to notify the customer of any impending charges in the car or routine service. Thus, it is humbly contended that Muskla Incorporated and Muskla Aharat are intermediaries. As seen from above, Muskla Incorporated and Muskla Aharat qualify under Section 79 of the Information Technology Act as the other to Section 79 subsection 2 clause B. Your Lordship, coming to the second full of the argument, the Council contends that the intermediary didn't receive actual knowledge and observe due diligence. In Shreya Singhal versus Union of India, the court held that Section 79 is a valid subject to Section 79 clause 3 subsection 3 clause B being read down to mean that an intermediary, upon receiving actual knowledge from a court order or on being notified by appropriate government or its agency, it is humbly contended the actual knowledge can be received by the intermediary either from any concerned user, subscriber, or another person by their communication in writing or by a legal notice indicating that any information, data, or communication link residing in or connected to a computer resource controlled by an intermediary is being used to commit the unlawful act. Further, the intermediary can also be notified by the appropriate government, central government, or state government, or any of its agencies, including law enforcement agencies, of committing any unlawful act.
Counsel, sorry to interrupt. You were saying that you are only an intermediary. Then who is the actual service provider in this case?
Your Lordship, we
in order to run the car, you need the server access, right? Can the car run without the server access from you?
No, Your Lordship.
So who is the actual service provider?
Muskla in US, Muskla Incorporated.
Okay, so that's the parent company is the actual service provider. Please continue.
Your Lordship, the Council would like to draw the attention of Your Lordships to page 1, paragraph 6, which says the M will also have an embedded 4G card which will communicate to Muskla servers in the USA. Your Lordship, under the definition of intermediary, network service provider have been claimed to be an intermediary. Your Lordship, Council seeks a 2-minute extension to conclude the argument.
Yes.
Much obliged, Your Lordship. It is humbly contended the actual knowledge can be received by an intermediary either from any concerned user, subscriber, or another person by their communication in writing or by a legal notice indicating that any data communication link residing in or connected to any computer controlled by an intermediary is being used to commit the unlawful act. Further, the intermediary can also be notified by appropriate government, central government, or state government, or any of its agencies, including law enforcement agencies, of committing any unlawful act using the information, data, or communication link residing in or connected to a computer resource controlled by an intermediary. Your Lordship, Muskla Aharat has been observing due diligence, that is fixing the vulnerability as soon as possible. The first vulnerability was fixed within 6 months and the next vulnerability was fixed within 10 days. Thus, it is humbly contended that Muskla Incorporated and Muskla Aharat have adhered to Section 79, subsection 2, clause B and subsection 3, clause B. Lastly, the Council contends the newspaper report is inadmissible in the court of law. The contention of the council is that Bharat Times newspaper report claiming that 70% of the car have used the autopilot feature, and to find an internal leaked memo alleging Mr. Dusk was aware of this and silently encouraged the use of autopilot feature is inadmissible, illegible, and unreliable. In SP Sen Bagamurthy versus Dr. Chenna Reddy, it was held. We cannot take judiciated in the news item, being in the nature of hearsay, secondary, unless police challenge it. A report in a newspaper is only hearsay evidence. A newspaper is not one of the documents referred to in Section 78 Clause of the Evidence Act 1872, by which an allegation of fact can be proved. The presumption of genuineness attached under Section 81 of the Evidence Act to a newspaper report cannot be treated as proof of fact reported therein. It is now well settled that a statement of fact contained in newspaper is merely hearsay and therefore inadmissible. Similar was held in Vinod Kumar Jain versus Guwahati Municipal Corporation and Tulsi versus Besar. It was held that under Section 81 of Indian Evidence Act, the presumption of genuineness attached under this section to a newspaper cannot be treated as a proof of fact reported therein, and the statement of fact contained in newspaper is merely hearsay and therefore inadmissible in evidence. Your Lordship, the Honorable Supreme Court had a similar stance in B. Singh versus Union of India, Krishnama versus Government of Tamil Nadu, and Ravindra Kumar Sharma versus State of Assam. Therefore, the Council humbly contends that the genuineness of report and leaked internal memo is unreliable and hence not admissible in the court of law. If your Lordship is content with the argument presented by the Council, I would now request my co-counsel to deal with the remaining two issues.
Yes.
Okay. Thank you.
Greetings of the hour, your lordships. This is TL Speaker 2 appearing on behalf of the petitioners for this case. Your lordship, if it may please this court, the council would like to address the issue number 3, that is whether Muskla Inc. Corporation's Muskla Aharat can claim any immunity from prosecution under the Penal Code and the Motor Vehicles Act, your lordships.
Yes.
Yes.
Your lordships, it is humbly submitted that Muskla Inc. Corporations and Muskla Aharat can claim immunity from prosecution under the Penal Code and the Motor Vehicles Act. Your lordships, the proposition provides that a criminal case was registered against Dusk and the CEO of Muskla Aharat, Dhanraj Pillai, under 304A of the Penal Code. They were also booked under Section 188, read with 184, 190, 198 of the Motor Vehicles Act. Your lordships, as per the Indian Penal Code 304A, which reads about causing death by negligence, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either a description for a term, which may extend to 2 years, or with fine, or with both. Your lordships, in regards to this very section, page 3 of the proposition clearly provides that Muskla Inc. Corporations disclaimed any liability from the autopilot use and had entered into an end user's license agreement. Your lordships, the agreement reads as follows. If you are using autopilot from a country where it is not made available, you violate the terms of this agreement and your use of them could be suspended. Making any changes, modifications, or changes to the firmware is explicitly prohibited. And we reserve the right to suspend your online account with Muskla. Your lordships, the council contends that despite of taking and undertaking reasonable measures and issuing disclaimers such as the aforementioned one, persistently, Kim hacked the autopilot mode while on her way to work. The key aspect here is that, your lordships, she did this voluntarily, which brings us to the gross violation on her part. Your lordships, it also brings us to the chapter 4, that is the registration of the Motor Vehicles Act in 1988. Your lordship, section 52 of this act reads that alteration in motor vehicle, no owner of the motor vehicle shall so alter the vehicle that the particulars contained in the certificate of registration are at variance with those originally specified by the manufacturer. Your lordships, when the car M was first introduced on the roads of Aharat, it was done so without the autopilot feature. This made the car a class 4 level automation, which does in fact require a driver to be present behind the steering wheel to take control of the cars at all times mandatorily.
Council, if that is the case, why the CEO, Mr. Dusk, has made a statement during the inauguration? What was the reason for that? Does it not amount to...
Your lordships, Dusk indeed had made a statement. However, that's statement was led to speculations, and that speculations had been weighed off in the tweet that came out after a few days. Your lordships, in the proposition page number 3, paragraph 2, it's clearly said that the tweet read, I meant that people could drive M's in other countries. We take this vulnerability very seriously. The problem with fixing it is that we also need a downtime for fixing it. We cannot apply a patch for fixing it until we find a moment where all the drivers in the world are not using autopilot, since the autopilot servers are in the USA. Your lordship, in this very tweet, thus proclaims that he had not meant what was speculated majorly and vastly by the public, your lordship.
And an internal memo showed that Dusk himself was aware of this and encouraged the use of autopilot feature.
The council understands, your lordships. However, it has been vastly and exhaustively covered by my co-counsel that a newspaper report is a hearsay evidence and is not admissible in this court, your lordships. This internal memo has no liability. It has no reference to take from, your lordships.
The Evidence Act, that's not strictly applicable to the Supreme Court. We receive it, we believe it. If we believe the newspaper report, what is your comment on it?
Your lordship, the newspaper report published by the newspaper has no secondary backing. It has no affirmance from an investigation that may have been headed by the government itself as well. Since there is no affirmation or seconding the report, the council pleads to the courts to not refer to the issued
and
report.
again, while live video was going on, your social media team immediately tagged this to tech support team of Muscler. So all this shows that your active involvement in this.
The council understands, your
You
lordship.
can't say that you were not aware.
The council understands, your lordship. However, it does not completely agree with this statement. Your lordship, Muscler Aharat's social media team had indeed, in fact, immediately tagged this to the tech support team of Muscler US. Your lordships, as actions were being pursued, within 10 brief moments of this, Kim's car met with an accident. It was too early for the company to intervene at this point and change the discourse of events, your lordships. It was made aware, but however, the time period being too short between the reaction of the government and the accident of Miss Kim has been a very difficult situation, your lordships. If we would have went on to take control and disable it in the midway, your lordship, that would have led to an accident, your lordship, as she was driving at the speed of 100 kilometers per hour on a highway, your lordships. If the court is content with the questions and the answers posed by the council would like to move on with the further arguments, your lordships.
Yes.
Indeed, your lordships. Due to a clear breach of the section 52, that is the alteration of the motor vehicles, wherein your lordships, Kim went on to reverse engineer and hack into the firmware of the car, turning it from a class level 4 automation to a class level 5 automation, your lordships. For the purpose of explanation of this court, a class level 5 explanation of the automobile does not require a driver to be present behind the steering wheel at all. However, this was not as the car was originally registered. Originally, it had always been a class 4 automobile, your lordships, which did require a driver to be present behind the steering wheel at all times. Due to a clear breach of this section, the petitioners humbly submit and requests it to be duly noted that Kim has hacked the firmware, violating not only the end user's license agreement, but has also done it on numerous occasions, as mentioned clearly in the proposition, your lordships. Furthermore, subsection 3 of this very act also reads that where any alteration has been made in the motor vehicle without the approval of the registrating authority, or by reason of replacement of its engine without such approval under the subsection. This is another aspect to focus upon, your lordships, a shortcoming on Kim's part, for which only she can be held solely liable and accountable, your lordships. The council would now like to move towards the chapter 13, that is the offences, penalties and procedure of the Motor Vehicles Act in 1988. Your lordship, section 1.
You have abetted it. Maybe Kim was responsible. She was driving the vehicle, but of course, you have abetted it.
The council requests clarification. Is your lordship referring to the abetment by incitation?
Yes.
Indeed, very well, your lordships. Your lordship, for it to be abetment of incitement, it has to be an action of instigation, encouraging or promoting a person to commit an offense. However, your lordships, in this case, via the tweet, that has already been clarified that there was no intentions on the part of Dusk to encourage such an unethical hacking of the EU entity, your lordship.
This memo shows that you have tacitly encouraged the use of autopilot feature. Is it not an abetment? And you have circulated, you have tagged this video while the video was going viral. Are these not instances of abetment?
Your lordship, the council understands, however, it does not completely agree with the statement, as when the video was going viral, your lordships, Twitter has 396 million users. There is no chance Mr. Dusk could have known that Kim Veer Singh was from Aharat, your lordship. And however, if this may not be a case, your lordships, when the video was going viral,
all the circumstances show that you encourage the use of autopilot feature, or you are not prohibited the use of autopilot feature. So it amounts to abetment.
Indeed,
all the circumstances show.
Indeed, not your lordship. When the video was going viral, it was only being tagged by the US Muscla team just for the notification purposes and to make them aware of the breach that was being brought on by the part of Kim Veer Singh, your lordship. Not only this, but the part of the proposition on the first page itself clearly provides that Delaware had launched M in Aharat without the autopilot technology. It had taken all due diligent care and prevented from its side where the autopilot mode, which is usually sold as a separate add-on for $5,000 for 500 hours of drive time, and this option to purchase the autopilot mode was disabled on Muscla Aharat's website. Your lordship, the company had already been made aware of the vulnerabilities as well. However, it has clearly worked and put up and issued patch notes to prohibit further hacking into the system, your lordship, and that is clearly visible as provided by the fact sheet as well, your lordships.
Counsel, you missed a point. There is no charge of abetment. There is no charge of abetment. Without a charge of abetment, how can you be prosecuted? You missed that point.
Indeed, your lordship.
Section 109 or 34, nothing. 120B, nothing. So you can't be independently prosecuted. Did not for 279, nothing. Because you didn't drive the vehicle.
Indeed, your lordship.
Only with the aid of section, either under section 109 or 34 or 120B, you could be prosecuted. No such charge.
No such charge has been levied, indeed, your lordship.
Yes.
Your lordships, the council would like to now move on to its further arguments. It is humbly submitted to the court that there have been no breaches or malicious or fishy intentions on the part of Muscla Inc. or Muscla Aharat under the Penal Code nor the Motor Vehicles Act, and hence the same can claim immunity from prosecution. The council would now like to move on towards the fourth issue, that is, if the above issue is answered positively, then can Dusk and Dhanraj also claim immunity from prosecution, given that they are just mere officers of the Muscla Inc. and Muscla Aharat respectively. Your lordships, when it comes to Dusk and Dhanraj exercising immunity from the prosecution, the learned court must make a note of a few facts. It is possible to hold a manufacturer or a dealer liable for negligence if the plaintiff can show that the manufacturer owed a duty of care to the plaintiff in relation to the product that the manufacturer breached a duty of care, and the product injured the plaintiff. In product liability cases, your lordship, the negligence tends to be more difficult to prove than strict liability, simply because it requires evidence of a specific set of actions performed by the manufacturer, your lordship. Product liability has also been defined under the Consumer Protection Act of 2019, that it means the responsibility of a product manufacturer or a product seller or a product service provider to compensate for any harm caused to a consumer by a defective product, your lordships. In our case, there has been a blocking of a feature from coming in effect. This in no way can be termed as a defectivity, your lordships, and hence there is no product liability on the part of of the company Muscla Incorporations or Muscla Aharat. Your lordships, a perusal of the definition of product liability also reveals that in order to establish a claim of such, the complainant must establish harm caused by the defective product. However, therefore, the product not being defective in our case, your lordship, the absence of any harm caused to the consumer by use of the product are certainly valid defense to a product liability action. In addition to the above, the council would like to draw the attention of the court towards Section 87 of the Act that envisages the below mentioned as a defense to product liability action. Subsection A reads, in case of a claim against a product seller, it would be a valid defense that at the time of the alleged harm, the product was misused, altered, or modified. In our very case, however, your lordship, there has been a severe disconnection between the liability. Despite of being aware that the laws prevent alteration and being forewarned by the government, by the company, on their part, by the EULA as well, your lordships, not once, but twice Kim went on to reverse engineer and hack into the firmware of car M. And hence herself has altered the mechanism by reverse engineering it into a class 5 mechanism automobile. As per the aforementioned provisions, there is no liability on the side of the petitioners. Your lordships, a company or a manufacturer won't be liable. However, the users tamper with the product and put it in a dangerous condition. The same was upheld in the judgment of Warren Silverstein versus Wash Press and Die Company. In this case, your lordships, the petitioners had pressed for damages after losing several fingers when a Walsh-built punch press machine malfunctioned. He argued that Walsh had not built in adequate safeguards into its machine and had never warned people about the potential hazards. Your lordships, Walsh, however, demonstrated clearly in the court that the punch press had been modified by others in the 34 years since it had left the factory. The motor, pedal assembly, flywheel guard, the cam switch differed from those that Walsh had originally installed. Somebody had removed the original safety devices. A manufacturer can't be held liable for such injuries. That was decided by the court when a product is radically altered. Your lordships, in our current instance as well, Muscla Inc. and Muscla Aharat
Is it about immunity from criminal prosecution? That decision.
Indeed, your lordships, it was on April 14th, 1986, whereas this was heard in the Suffolk County, where Justice Doyle
Also, my brother judge is asking, is it with respect to the criminal liability? Because there is no product liability or damages before us.
Indeed, your lordships, but the council contends to prove that there is no criminal liability, but not only that, but there is also no civil liability on the part of the company as well. The council shall be getting to this very aspect in its further arguments, your lordships.
Yes.
In the current instance, Muscla Inc. and Muscla Aharat cannot be held liable as the autopilot system is a level 4 autonomous vehicles integration. It mandates the presence of a driver in the driver's seat to supervise and steer the car whenever necessary. One of the prime factors that have not at all been pondered upon is the absence of mens rea, your lordships. There have been no such intentions or negligence on the part of Muscla Inc. Corporations, Muscla Aharat.
Where is the question
Melon
of
Dust.
mens rea? See, where is the question of mens rea in rash and negligent act?
Your lordship,
It's not something intentional. Mens rea is applicable only to intentional acts. In rash
Indeed,
and
your
negligent matter, where is the question of mens rea?
Indeed, your lordship, the council understands, but it is sidely also proving that despite of there being no rash and negligent act on the part of the petitioners, there can also be no proved mens rea on the part as well. So they cannot be booked under not only 304A, but under any section when it comes to the Indian Penal Code, your lordships.
Counsel, what is your answer for the rash and negligent statement made by Mr. the CEO of Mr. Dusk, and also knowing that there is a vulnerability, how you release the product in the market? Is
Your
that not
Lordship,
amount to rash behavior, negligent behavior?
That too
Indeed, Your
without taking any precaution.
Indeed, yes, your lordships. When the product was first introduced in the market, it was done so without the autopilot technology, which was also affirmed by the government as well, your lordships. Also, there was the disablement of the purchasement of the autopilot add-on mode from Musla Aharat's website as well, your lordship. The company, while releasing the product, was not aware of any such shortcomings on its forth. However, when it was later on hacked by the users, the company has not once but twice came out with patch notes and has done so in very short periods of time. Although it may have taken a period of 6 months to fix the first vulnerability, it is rather appreciable that it came out with the next fix note in 10 days. Yes, your lordship.
Counsel, that statement, that argument is not correct, because just after launch event, your Dusk publicly spoke that I know some of you are disappointed. You know that you can't use the autopilot in horror, but if you want, you can always try, different ways. That was the statement.
Indeed, your lordship. However, Dusk's team and Muscla Inc. corporations on their part have also conveyed that this was wrongly speculated by the people, by the users of Aharat, and the same has also been contended in the fact sheet as well. The line right after it clarifies that Dusk meant that people could drive M's in other countries, and that they take the vulnerability that has been identified very seriously. They are fixing the same with immediate effect as well, your lordships. If your lordships are content with the answers, the council would like to move on. Indeed, your lordships, the council is proceeding with the arguments. Your lordships, section 304A of the IPC provides punishment. The essential ingredients of the same are firstly the death of the person in question. Secondly, the death must be caused by the accused. Thirdly, the death must be caused due to rash or negligent act of the accused. And fourthly, the act must not amount to culpable homicide. Additionally, your lordships, there necessarily should be a clear connection between the accused negligent and rash act and that of the death of the person. Section 304A will not be applicable if the death is neither the direct result of a negligent or a rash act on the part of the accused, nor the efficient and proximate cause without the intervention of another's negligence. Your lordships, here the council would like to include the legal maxim of causa proxima non remota spectator.
Counsel, Kim was not charged under section 304E. She was charged for reckless driving only. How would it help you?
Your lordships,
Kim, who was actually driving the vehicle and caused the accident, was not charged under section 304E. She was charged, I understand, for reckless driving only. That is 279. Then you were charged under section 304E. How would it help you? What is your take on that?
Indeed, your lordship, the council understands. Your lordships, Kim was charged with only reckless driving, but that is the current scenario as per the present time. Your lordships, the further charges have not been levied onto her, and as wherefore, when this court makes its judgment, that shall come into light that only Kim was responsible for acts that were solely and wholly. She can only be held accountable for that, your lordships. The petitioners cannot. The council would further like to contend with its arguments if the
council, the driver who was driving the vehicle at the time of accident.
Your lordships, Kim Veer Singha was supposedly driving the vehicle.
No, I'm not asking who was sitting in the driver's seat. Who was actually driving?
Your lordship,
can we make such a difference?
There was a hack. Autopilot. Indeed, your lordship, there was a hack accessed by Kim where she placed heavily adhesive gloves onto the steering wheel that led to the autopilot system, which was again hacked and not ethical, your lordships. That autopilot system was led to believe that Kim was in fact holding the steering wheel.
By legal or illegal, at that time, your autopilot system was driving the vehicle.
Indeed, yes, Your Lordship.
Yeah, proceed.
The council would like to proceed and argue that although the autopilot system was driving, the autopilot system and the shortcoming cannot be blamed onto the petitioners, Your Lordship, since that feature was completely disabled. One. Two, that feature was not allowed and prohibited not only by the government but also by the end users license agreement to be used on the streets of Bharat, Your Lordship. With this, the council would like to move on towards its concluding statements.
Brother Surya, that's indeed an interesting point. Brother Surya, that is indeed an interesting point. Because
Yes,
actually, Kim was not driving autopilot system. So we have to rewrite 304A if we introduce autopilot system in our country.
Indeed.
Yes, again putting another question, like we are now facing like whether those people like an autopilot is an AI, can they be treated as an artificial person, and how much criminal liability can be fixed on them?
Exactly.
The council as well agrees with Your Lordships, as it is also mentioned on page 2 of the proposition that the Ministry of Roads and Transports had not yet issued any approvals, and the government also responded that the Motor Vehicles Act as well needs to be amended from a road and safety transport perspective when it comes to autopilot integration, Your Lordships. With this, Your Lordships, the council would like to state its concluding arguments.
Right.
Section 304A of the IPC provides punishment and hence cannot be punishment for causing death by a negligent or a rash act. The death should be a direct result of the accused. That is, it should be causa causans. In the present case, there is no direct nexus between the actions of Dusk and Dhanraj and the death cause. In fact, there would have been not negligence on the part of Kim as well if the accident would not have taken place. Your Lordship, Section 198 of the Motor Vehicles Act deals with unauthorized interference of the vehicle as well. In the present case, it is Kim and not Dusk or Dhanraj who tampered with the mechanism of the car. Thus, in light of the above contentions, it is submitted that Dusk and Dhanraj can claim immunity from prosecution under IPC and the Motor Vehicles Act. With this, Your Lordships, the council would like to move towards its prayer.
Okay.
Wherefore, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, this honorable court may be pleased to find that 1. The government of Bharat's ban order prohibiting EMS firmware or EMS app to access its server maintained by Masla Inc. by connecting to the internet within Bharat is invalid under Section 69A of the IT Act and must hence be lifted with immediate effect. 2. Masla Inc. corporations and Masla Bharat can be termed and have been established as intermediaries under the 79 of the IT Act. 3. Masla Inc. corporations, Masla Bharat can claim immunity from prosecution under the Penal Code and the Motor Vehicles Act. 4. Dusk and Dhanraj also claim immunity from prosecution given that they are just officers of Masla Inc. and Masla Bharat respectively, and pass any other order, decree, or judgment that it may deem fit in the ends of justice, equity, and good conscience. And for this act of kindness, the petitioners shall be duty-bound and ever humbly pray. Your Lordships, it has been indeed a pleasure of the Council to present this case before your high-valued eminence and this Honorable Supreme Court of Indica.
You don't want costs. You don't want costs. Cost of the proceedings.
That is not prayed for currently, Your Lordship. The company is very well concluded when it comes to the costs, Your Lordships. But thank you for the very valuable suggestion, Your Lordship.
Yes, thank you very much. You presented well.
Thank you, sir.
Thank you. Since the tweets were happening against your company is in planning to get the Twitter company itself. Mr. Dusk is in talk with the Twitter company.
Indeed, Your Lordship. That seems to be the case. Rather ironic.
Thank you, TL01. With the permission of the judges, I invite TL08, Speaker 1, counsel for the respondent.
Can I have a one or 2 minutes break before starting?
Sure, Your Lordship.
1 minute, 2 minutes. Okay.
Just to confirm, am I audible and visible?
Yes.
Warm greetings to the bench and the opponent counsels. May I please the Honorable Court. This is the Attorney General appearing on behalf of the respondents. In the case of
Counsel, 1 minute. Brother Justice is still not to be seen on the screen.
Biju.
Yes, I'm back. Yes, we can continue. Yes.
Much obliged, much obliged. May I please the Honorable Court. This is the Attorney General appearing on behalf of the respondents in the case of Masla and others versus Surana Faharat. With the due permission of the bench, may I address the bench collectively as your lordships?
Yes.
Much obliged. If the lordships are well versed with the facts, may I move on to the issues?
Right.
Much obliged, your lordships. Your lordships, there are 4 issues in the present case. The first issue will be whether the government of Bharat's ban order prohibiting M's firmware or M app to access its server maintained by Masla INC by connecting to the internet within Bharat is valid under Section 69A of the IT Act. The second issue will be whether Masla INC and Masla Bharat can be termed as intermediaries under Section 79 of the IT Act. The third issue will be whether Masla INC and Masla Bharat can claim any immunity from prosecution under the Penal Code and the Motor Vehicles Act. And the final issue will be if the above issues answer positively, then can Dusk and Dendroids also claim immunity from the prosecution, given that they are just officers of Masla INC and Masla Bharat respectively. I will be dealing with the first 2 issues for 21 minutes, and my co-counsel will be dealing with the rest of the issues for 21 minutes, saving 3 minutes for surreptance. May I move on to the arguments?
Yes.
Much obliged. The first issue in the present case will be whether the government of Bharat's ban order prohibiting M's firmware or M's app to access its server maintained by Masla INC by connecting to the internet within Bharat is valid under Section 16 of the IT Act. The council would like to answer this issue in threefold manner. Firstly, the ban order is well within the ambit of Section 69A and it is not arbitrary. Secondly, the ban order clearly passes the proportionality test. And thirdly, the ban order stands with respect to the exceptions provided in the principles of national justice. Moving the first thing of the argument, your lordships, from a bare reading of the impugned provision 69A, the grounds for issuing a blocking order are the interests of sovereignty and integrity of Bharat, defense of Bharat, security of the state, friendly relations in the foreign states, or public order for preventing incitement to the commission of any cognizable offence related to the above. Your lordship, in Section 69A of the IT Act, is read with rule number 9 of the IT rules. It provides for emergent situations to impose a ban on the applications. Again, in rule number 9 of the blocking rules, however, it supersedes the rules which is laid out in rule number 6, 7, and 8 of the same rules if there is an emergency. If I quote the case of Brahmana Loya of the state of Bihar, the Supreme Court held that in the case of public order, the community or the public at large have to be affected by a particular action. In order to prove this, the council would like to bring upon the test of reasonableness in the present case. In the case of Arun Ghosh versus State of West Bengal, AR 1970 SC 1228, where the court laid down the principle of public order, it has held as follows, your lordships. When there is a disturbance with the current life of a public at large, it will clearly lead to a disturbance of the public order. When it is up to the present case, your lordship, it is to be noted that more than 40,000 cars have been sold and it was made sure that 70% of
But there was only one incident of accident. Is it not premature? Is it not premature? Because immediately after the first accident, the ban order was issued. That too, even without giving any notice. So where is the question of public orders? True, a newspaper report is there. There is 70% of use of vulnerability, but that there is no valid proof. Still, only one accident took place. Immediately, the ban order was issued.
Indeed, not yellow.
And of course, it's not in the interest of defense, sovereignty, integrity, or security of India. No doubt. So only you can bring it within the ambit of only public order. So where is the question of affecting the public order when only one incident of accident was taken place? That too without giving them an opportunity to correct it.
Your Lordships, there is not only one incident. If I may,
not in a hurry.
Your Lordships, if you may refer to the proposition, it has been clearly held that 70% of them have used the autopilot technology out of 40,000 cars. And also, Your Lordship, this can be connected to a chain of events. Your Lordships, after the incident, Elon Musk has tweeted a tweet.
Even if 70% used it, then unless accident doesn't take place, where is the question of affecting the public order?
Indeed, yes, Your Lordship.
There are so many hackers. So many hacking taking place in this country. Can you say that all those affect the public order?
Your Lordship, this cannot not only viewed on the grounds that there is an accident occurred, it should also be viewed in the situation of the society, Your Lordship. There are various criticisms, various disruptions caused in the society after the accident. People were in a state of unrest, Your Lordships. And thus it clearly proves for the ground of public order in the state. And thus the government is authenticated to issue a ban order under Section 69A of the IT Act.
See, what are the material collected by the government to prove that there is violation of public order, or rather it affected public order? Apart from this paper report and the one accident.
Your Lordships, regarding the paper report should not be seen as merely a paper report, Your Lordships. It has an internal memo, Your Lordships. If I may quote the case of Yashwant Sinha vs. CBI 2022 SCC 392, where the court admitted the memo relating the Rafale arm deals, which was published in the Hindu newspaper, which the court held that it will qualify as a published record. So in the present case, we can also observe that this internal memo will qualify as a published record, and thus it can be admitted in the court. This is being one of the grounds where the company was well aware of the fact that there was a use of autopilot technology, and thus
in this country, even now, invoking Section 69A, we couldn't ban pornography. That's a serious threat to the nation. Serious threat to our future generation. Even we couldn't ban pornography.
Your Lordships, but the child pornography was banned with the same provision.
That is statutorily banned. That is statute. It is there. It is an offence. What about other pornography?
Your Lordships,
is it not a big issue of public order? Pornography.
Indeed, yes, Your Lordships, but the issue of pornography will not derive any nexus to the present case, Your Lordships.
It has. When we
Your Lordships, if I may.
Yes,
Council will come this way. Council will ask in another way. Like you were saying that the company's website is being hacked by someone. What was the action taken against the hackers?
Your Lordship, it is the duty of the company to make sure that, if I may, Lordship, if I may quote the intermediate rules 2021, rule number 3, where it has been clear that due diligence has to be taken care of, and the reasonable measures should also be taken care of for any computer resource. They should safeguard their own resources, but the company has failed in this. It is the fault of the company, not the government, Your Lordships.
And 69.
Is it a private breach of contract, or is it an offence?
It is an offence, Your Lordships.
So what is the action taken by you?
Your Lordships, that is why now there was a lot of vulnerabilities right from November, right from the launch of the event. First vulnerability was fixed. The second vulnerability and the last vulnerability was not fixed, your lordships. Especially the second vulnerability, which lasted for 45 minutes, it was not fixed by the company. And again, we were waiting for the company to fix it, but it was not fixed. Again, when the accident happened, they came up with a high wash called geotags, which was also not implemented properly by the company. And thus, the government was left with no option just by imposing a ban on the company, your lordships.
Council, Section 69A says that you should record reasons in writing, and the order does not reflect any reason for the ban, except for quoting Section 69A.
Your lordships, Section 69A should also read with rule number 9, where in an emergency situation, without any notice, the government can impose a ban order on emergency situations. Again, your lordships,
but should there not be any reasons in the order for banning it?
Your lordships, the main reasons which can be this was imposed in an emergency situation. Thus, we can infer that due to the effect of public order and sovereignty and integrity of Bharat, the government has.
What was the emergency? What was the emergency?
As I said before, the vulnerabilities were not fixed, your lordships. There was still 2 vulnerabilities which was not fixed by it, and it was also to be noted from the internal memo which was leaked that 70% of the 40,000 cars were still using autopilot. So it might lead to a lot of breach of public order, your lordships, and thus this can be noted down as a main criteria for imposing a ban, your lordships. And again, for any document or complaint received in writing, the internal memo can also be admitted as evidence, your lordships, and thus this can be proved. May I move on with the arguments?
Right, move.
Yeah, your lordships, with respect to the sovereignty and integrity of the Aharat, the question raised by one of the lordships. From the beginning, Masla, INC, and Aharat executives were well aware of the vulnerabilities of the technology. A sovereign state like Aharat cannot afford to limit its safety to mere traffic incidents caused by compromised technology. Unfortunately, this compromised technology is a national security threat from the countries, an organization looking for ways to exploit vulnerabilities in the technology by extracting sensitive and critical information about Aharat citizens and Aharat road patterns. It can also create security threats, but of great value to any country or organization waiting to conduct an attack or activity that could seriously compromise Aharat's national security or lordships. And thus, this ground is also getting satisfied. If your lordships are satisfied with the first limb, may I move on to the second limb of the personality test?
Okay, proceed.
Much obliged. Your lordships, with respect to this limb, I would like to rely upon the legal principles which was laid down in case Puttaswamy versus Union of India and Anuradha Basan versus Union of India, where the court emphasized that on the balancing and the necessity stage. Also, your lordships, the impute order clearly had a sanction of Section 69A of the IT Act, and thus it stands with the principle of backing of the law. With respect to the necessity stage, your lordships, it is evident from the chain of events that there were several vulnerabilities occurred in Karem, where the last two vulnerabilities, that is the vulnerability which occurred somewhere in 2020 when after the first vulnerability, which was under the vulnerability which was found by Kim, was not fixed until a collateral damage occurred. It is also to be noted that Masla had the full knowledge about the vulnerability being existed and still kept silent to use this as an initial day, in the initial days as a trial period to introduce an autopilot feature in near future, your lordships. When the vulnerabilities are strong enough to take the lives of the citizens of Bharat, it clearly dilapidated the public order, and the state cannot be merely watching this, and thus there arose the necessity of ban under Section 69A of the IT Act, your lordships. Thus, the necessity stage has been clearly satisfied in the present case. Again, with respect to the balancing stage, your lordships, when the economic interest of Masla INC and the public interest is put for the balancing test, it is clearly evident that the public interest will outweigh the economic interest of the corporation. Moreover, this ban is well accordance with the reasonable restrictions, which is laid on Article 19+2, and thus it stands valid, your lordships. If the lordships have any,
does it not violate the principles of natural justice, sir?
The council will be coming to the next limb will be regarding this, your lordships.
Right.
May I proceed with the next limb?
Right.
Your lordships, when Maneka Gandhi versus Union of India is observed, which establishes the exception of rule of adi autem partem, where statutory exceptions was held as a valid ground of exception, your lordships. Again, relying on Shreya Singhal versus Union of India, where it was clearly held that in emergency cases under rule number 9, blocking is done without giving opportunity of hearing, with adequate safeguards, your lordships. thus it qualifies a reasonable exception under law, and thus it passes the exception provided under RD Altum Part.
See,
If Lordships have any further queries?
see, going to the ban, all cars were rendered useless.
Indeed. Yes.
Right. Then you could have at least issued a notice.
Your Lordship, as I said before, it is an emergency situation, and
What
when
is
the,
emergency?
Your Lordship, coming to the first claim of the arguments, where I have clearly stated that 70% of 40,000 cars are using this autopilot technology and is keeping on hacked by the hackers, and the company has not even taken any
When
due
did
diligence.
you come to know? When did you come to know that 71% of the car use vulnerability? When did you come to know?
When the internal memo was leaked, we were aware of that.
When was it? Still, there was time to issue shock cause notice.
Your Lordship, it wasn't like as I said before, the action was taken in a very time-to-time manner, Your Lordships. When the memo was leaked, we have taken this order in just a 5 days of gap, Your Lordships. Where the measure was introduced on March 10, the geotags. With respect to geotags, Your Lordships, if I may refer to the intermediary rules, rule number 3, clause 1, subclause I, where it's clearly stated that any reasonable measures taken by the intermediary, if they are considered to be an intermediary, should comply with the ISO standards, which is clearly mentioned in the, if I may take a moment, Your Lordships, which have been clearly mentioned in the subsidiary ID rules, that, and also if you observe, the geotags will not qualify as a thing under the ISO standards, Your Lordships, and thus that cannot be taken as a mere solution for the accidents which have been happening, and thus it forms an emergency. Still, the vulnerability is being not fixed, Your Lordships. It stands not fixed. Then there is an emergent situation. It proves for an emergent situation.
Later on, it was fixed. No.
That is why, Your Lordship, the geotags is not valid under the ISO standards, which was established by the IT rules. And thus, it is not a valid solution for the vulnerability which has been aroused. Now, Your Lordships, if I may quote, if I may direct you to the proposition, there was one vulnerability where after the first vulnerability, 45.
Initially, within 10 days, it was fixed.
Your Lordships, it was not fixed. It was just an eyewash. It was not with the ISO standards. It cannot be claimed that it was fixed.
Okay, did you ask them to fix the vulnerability?
It was the duty of them to have the due diligence, but they failed.
Did you ever ask them to fix the vulnerability?
Your Lordship, that is why we have imposed the ban, because they were acting like they were not acting in due diligence. That is why we have ordered a ban in order to protect the public order in the present situation.
Your ban is not affecting the company alone. 40,000 citizens who have purchased.
No need of adequate notice to be introduced to the other party, Your Lordships. And also with respect to Your Lordship's previous question, where the economic interest, and when the public interest and economic interest is balanced, the public interest will outweigh the economic interest, and then the public interest should be considered than the economic interest of the 40,000 people. Like, what if there is a situation where the 70% of the cars will have regular accidents? It is a duty of the, and also, if I may quote Article 38 of the Indian Constitution, Bharat has been observed as a welfare state. So it is a duty of Bharat to maintain welfare in the state.
Yes.
Indeed, yes, Your Lordships. If Your Lordships are satisfied with the contentions, may I conclude the first issue?
Right. Okay.
Much. Your Lordships, thus it is submitted before this honorable court that the ban is justified on the grounds that the ban is well within the ambit of Section 69A and not arbitrary. It stands the proportionality test, and the ban order is justified under the exception of principle of national justice. If Your Lordships are satisfied, the council seeks permission to move on to the next issue.
Right. Okay.
Your Lordships, the second issue will be whether Masla INC and Masla Bharat can be termed as intermediaries under Section 79 of the IDF. Your Lordships, apologies. It is for the kind attention of the bench and my learned counsels that there is an evident error in the written submissions regarding the second issue, Your Lordships. The council seeks apologies for the error, as we have submitted a petitioner's contention in the respondent memo as well. So with regards to this issue, it is like we will have the same contentions for the petitioner memo and the respondent memo. It was truly a negligence by the team, and we request the bench to permit us to argue the original contentions for this issue, Your Lordships.
Right, permit.
Much obliged, Your Lordships. Safe harbor protection, as they will not be covered under exemptions under Section 79 of the IT Act. Firstly, moving on with the first contention, that Masla INC is merely an originator but not an intermediary. As per the provisions of IT Act, Masla INC would be an originator as provided under Section 2, Clause 1, Subclause ZA, which gives the definition of originator, Your Lordships. It is clearly evident from the Moot proposition that M will have an embedded 4G SIM card, which will communicate to Masla servers in USA using mobile network operators network provided by the MNO. Without first connecting to the internet, M cannot be driven. So all the personal data are stored in the servers of Masla INC, making them as the originator in parallel with the above definition. Relying on Google India Private Limited versus Vishaka Industries, where it was held that the intermediary does not create data on its own and it stores the data on behalf of the third party. Your Lordships, here the Masla INC and Masla Bharat act as a single entity for the transmission of information, and there is no intermediary platform involved that act as a mutual point of exchange for information. Moreover, Your Lordships, here the firmware installed in CAR-M was creating the data through an analytical technique by themselves, and the same data is being communicated and stored to the servers of Masla INC in USA, which clearly depicts that there are no third parties were involved in the present case. The Masla Bharat and Masla INC will qualify as originator but not as an intermediary under Section 69A of the IT Act, Your Lordships. Moving on with the second limb of my argument, where even though, if for the argument purpose, if Masla Corporation is considered to be an intermediary, they will be liable for their acts because they were not in accordance with Section 79 Clause 3 of the IT Act, Your Lordships. If I may refer to Section 79 Clause 3 of the IT Act, which provides an exception to the immunity granted to the intermediaries from liability for third-party information and acts under Section 79 Clause 1 of the Act. Your Lordships, it gives two grounds for exception of this immunity, where the intermediary is guilty of conspiring, abetting, aiding, or including the commission of the unlawful act. Again, intermediaries fail to expeditiously remove or disable the access to any material residing in or connected to a computer resource upon receiving an actual knowledge. Your Lordships, from the Moot proposition, it is clearly evident that Masla INC was very well aware of the vulnerabilities, the hacking threats of CAR-M, and still the due diligence was not observed by the officials of Masla Corporation, and they were also silent on the point of not terminating the access of 70% of users who violated the end users license agreement and was collecting the data and using the initial, and they were using these initial days as a trial period to launch the autopilot technology. Lordships, the council seeks 3 minutes to complete the arguments, Your Lordships. The council will wind up in 3 minutes.
2 minutes granted.
Much obliged, Your Lordships. Your Lordships, if I may, again, coming to the point of end users license agreement, the company was aware of 70% users were violating the end users license agreement and was collecting the data, but it proves there was an actual knowledge involved on behalf of Masla Corporation in the present case. If I may also draw your Lordship's attention, as I mentioned before, to the intermediary rules 2021, where rule number 3, clause 1, subclause I, the Masla Corporation has failed to take all the reasonable measures to protect its CAR-M, when rule number 3, clause 1, subclause I is read with rule number 7 of the same intermediary rules 2021, the exemptions will not be applicable to the Masla Corporation, though they might be qualified as an intermediary. Again, Your Lordships, relying on Shreya Singhal and MySpace INC versus Super
Council, we understand that the negligence on the basis on the part of the company. Now, the transporting authority has a duty.
Your Lordships,
only a vehicle which is fit to be on road, that should be allowed. What was the diligence followed by them, due diligence, knowing that there is a vulnerability?
Your Lordships, if I may refer to the Moot proposition, the second page, where the Ministry of Road and Transports have no guidelines regarding the autopilot features. So the Ministry of Road and Transports requested the Masla Corporation to disable the autopilot feature. After we saw that they disabled the autopilot feature, we admitted them in the Aharat roads. But when this is, the corporation is liable of, they disabled the autopilot feature only in the websites. That it means it was the purchasing of the Indian note, Your Lordships, it was initially was not. If I may proceed with the arguments, much obliged, Your Lordships. As I quoted earlier, with respect to Shreya Shingle and MySpace INC with Super CUSAT Limited, where the court introduced the concept of actual and specific knowledge to hold the intermediaries could be liable. The seller and providing details of the seller, providing quality assurance, authenticity, guarantees, or storage facilities, assisting for placing a book of the product, creating a list of the product, packaging of the product with its own packing, transportation, delivery, and advertising products on the platform. So, if all the elements or if most of the elements are enumerated above are present, then such intermediary shall be deemed to be an active participant and cannot be exempted for the liabilities under Section 79 of the Act, Your Lordships. So from the above test, it is clearly evident that Masla INC, if considered to be an intermediary, if at all, if it is considered to be an intermediary, they will qualify as an active intermediary and thus they will be held liable, Your Lordships. Thus, it is humbly pleaded that Masla INC and Masla Harat will not qualify as an intermediary, but they will fall under the ambit of originator, and thus the exemptions are not applicable to the said company in the present case. If I may be of no further assistance to this court, the counsel would like to call upon my co-counsel to continue the submissions.
Okay.
It was a pleasure and honor arguing before this honorable bench.
Pleasure to hear you.
Much obliged.
Warm greetings to the bench and my learned counsel present here. This is the Solicitor General appearing on behalf of the Union of Bharat in the case of Masla and others versus Union of Bharat. Before I begin, I would just like to check if I'm audible and visible. Court floor manager.
Of course.
Much obliged, Your Lordship. So I will be dealing with the third and the fourth issue in a club manner, which being where the Masla Incorporation, Masla Aharat, can claim any immunity from prosecution under the Penal Code and Motor Vehicles Act, and where the Dusk and Danraj also can claim immunity from prosecution, given that they are just officers of Masla Incorporation and Masla Aharat respectively. Your Lordship, no immunity from prosecution can be claimed by Masla Incorporation and Masla Aharat. Masla Aharat had been selling the M cars in Aharat, and they are claiming that the autopilot technology, which is still not yet implemented and which does not come under the ambit of any of the statutes in the country of Aharat, is being disabled while they are being sold. But the cars being vulnerable for hacking, and people tend to eventually hack the autopilot technology and use it in their cars. And yet the company has taken no further actions with regards to the same, unless and until an accident which killed 2 people happened. Your Lordships, a criminal case can definitely be made under Section 304A of the Aharat Penal Code. The factual background of the present case, as per the prosecution, is that Kim's Yem, because of the failure of the autopilot technology embedded in it by Masla Incorporation, has involved in rash, was also held by this honorable court in the case of Badri Prasad Tiwari versus the state that, as regards the offence punishable under Section 304A of the Aharat Penal Code, it was observed that the point to be established is that the act of the accused was responsible for the death, and that such act of the accused must have been rash and negligent, although it did not amount to culpable
They
homicide.
have no direct role in the accident. This Dusk and Pillai, they have no direct role in the accident. They are only the officers of the company.
Your Lordship, if I may answer to your question, the knowledge here is not the direct knowledge. So I would like to bring in the concept that they, firstly, they had the knowledge that the autopilot technology was vulnerable for hacking. So that is the knowledge the council would like to place here. And also, if it was hacked and if the autopilot technology was not properly embedded in the car, or it was properly disabled in the car.
See, 304A and 279 is attributed to the accident in question, isn't it? Then they have these people, that Dusk and Dhanraj Pillai, they have absolutely no direct role in the accident. They are only the officers of the company. How can you attribute vicarious liability in a criminal prosecution, that too in a 304A and 279? Are they vicariously liable? See, and even no abatement could be attributed, even no charge. So how are they liable? Are they not entitled to immunity? So how can vicarious liability be attributed in a criminal prosecution? Of course, it is permissible in some cases, but 304A negligent cases, how is it possible?
Your Lordship, in the entire cause, vicarious liability is indeed attracted by Dusk and Dhanraj Pillai, because all over when they were liking the tweet, everything, it happened during the course of employment. If you look into the proposition, it is very clearly telling that Dusk had liked the tweet of Kim when she flaunted that. When she flaunted that the autopilot technology, she could hack it and use it for 2 hours. So it was very clear that Dusk had liked the tweet, and it was during the course of his employment. And also, with regards to the question that they are just officers, as you mentioned, we can indeed lift the corporate veil in the present case in order to determine the character of the officers of the company. So we are all well aware of the principle that was established in the case of Solomon versus Solomon, so which is telling that yes, the council is aware that a company gets a distinct personality, but there are circumstances when this corporate veil could be lifted and the character of the officers could be determined, and also when it is in danger of public interest, indeed, yes, that the corporate veil could be lifted and the character of the officers can be determined. If your Lordship is satisfied, may I please proceed with my arguments?
Okay, proceed.
Much obliged, your Lordship. So as I was mentioning earlier, with regards to the essential ingredients of the offences under Section 304A, also, your Lordship, as it was held in the case of Bal Chandra Vaman Party versus the state of Maharashtra, negligence is the act with the awareness that harmful or mischievous consequences will follow. As we all
Council, one point. Anyway, you would admit that these people, Dusk and Dhanraj Pillai, they did not directly involve, because admittedly they were not driving the vehicle. They are only so without a charge of abetment. How can you sustain the prosecution?
Your Lordship, firstly, I would like to answer to your particular question in twofold manner. So, as you mentioned earlier, they are not directly involved. So, this itself has, again, twofold answers. Firstly, that they were indirectly involved because they are the ones to sell the cars without completely disabling the autopilot technology, because it was them who made the autopilot technology vulnerable. And secondly, they this entire M car, so even if we say that the autopilot technology was there in the car, so the entire AI system, it is not an autonomous system. So it is always connected locally to an SD card, which is locally to an SD card, which usually provides a decoding key to a third party for an independent review. And in the present case, this third party is nobody other than the Masla Incorporation. It is the company who's maintaining the servers, the accounts of all the drivers who are using the M cars. So, which means that all the M cars, whichever is using the autopilot technology, is connected to the main server. So, which is being handled by the CEOs of the company, Dusk and Dhanraj, and no way we can say that Dusk and Dhanraj could be completely they can escape from the liability, because all the damage, the error that has happened in the technology is because of the server that is maintained by them.
Yes, Brother Surya was asking a question to the other council, that who was actually driving the car.
Indeed, yes, Your Lordship. I wanted to answer the question during the course of my arguments that if the driver would not be in an autopilot technology handled cars, it is not the driver who will be actually sitting in the driver's seat. So he can just sit back, he can just relax, but then he cannot. He need not keep his hand. But still, he's not supposed to turn out. Instead, he is supposed to keep his hands on the steering wheels and eyes on the road, because we cannot trust the technology every time, and it is always a human being who has to have an upper hand over the technology, and that driver should be ready to take over in case the system gets confused, or it is in case failing to recognize the objects or the dangerous traffic scenario. So the driver should definitely be sitting on the driver's seat, and he has to ensure that the wheel and the road, he has to keep his hand on the wheel and eyes on the road while the car is itself driving. But he won't be actually driving the car, but it will be the server which will be controlling the car's movement on the road.
Even there are driverless cars, remotely operated.
Indeed, yes. Indeed, yes, Your Lordship. So everything will be handled by the server of the company, and here the company is nothing but Masla Incorporation, Masla Harit, and this server is indeed maintained by the CEOs Dusk and Dhanraj in the present case. If Your Lordship,
Council, we understand that there is a negligence on their part, but again, we are asking when you are aware of that such a vulnerability in the system. That is, during the inauguration of the launch event itself, there was a tweet. Subsequent to that, there is a clarification tweet. In that, it says that there is a vulnerability. We take this seriously, and the problem is in the fixing. What was the action taken by you? Only will react after 2 people die, not before that. Can't we fix any liability on you?
Your Lordship, if I may answer to your question. So I think the answer is there in the question which you asked. So Dusk had tweeted that they are fixing the vulnerability. So when there is a company who has found that there is a vulnerability, and when they are taking appropriate measures to fix the vulnerability, the state, being the state, we do not want to interfere in the company's affairs unless and until it is affecting any public order, any public interest. So far, they have just said that a vulnerability is there and we are fixing into it. So we just wanted to give some time for the company to fix the vulnerability, and only after that, if in case they fail to do so, we were in a position to intervene in their affairs. If Your Lordship is satisfied, much obliged.
We are not satisfied, but still proceed, because like there is a break. You are saying that the government will see the break only after it fails. No, there is a quality standard exhibited. Similarly, in these new technologies, now you are sending a wrong signal to the other countries saying that totally banning the technology. Instead of that, you could have taken a precautionary measure saying that you come fit to our road, then we will allow you. Allowing then again stopping it is a bad thing to do.
Your Lordship, if you look into the proposition, the government never never allowed the company to sell the autopilot technology. We allowed the Masla Aharat in the country to sell only the M cars, and we strictly gave them instructions to not use the autopilot technology in the cars. But they designed the cars in such a way that the autopilot technology was made vulnerable. So we indeed gave clear instructions, and we did not license the company to sell the autopilot technology. It was the company's default to make it vulnerable, and not that of the states.
Please proceed.
Much obliged, Your Lordship. So as I was, Your Lordship, was there any question?
No, proceed. You may proceed.
Much obliged, Your Lordship. So, as I was telling earlier about the negligence, it is a well-known fact that every experiment is a way of risk-taking. And here in the present case, Kim was well aware of the fact that using an adhesive instead of her gloves was very dangerous, yet she decided to go about with implementing the innovative hack she had found. And also the negligence on the part of the company is that although it was well aware and it had the knowledge that people are hacking the autopilot technology by innovative ways, yet it had not taken any due diligence towards this. And as mentioned by my learned counsel for petitioners that about the end user license agreement, so Your Lordship, it was all just a disclaimer. So the due diligence was missing on the part of the company, which the state is actually now accusing them. So this is one of the due diligence part that the company missed. And also, Your Lordship, so when they are embedding the autopilot technology in the car, they should have also embedded only the reliable data in the car. And if you look into the proposition in paragraph number 20, it is clearly telling that the company has fed only non-reliable data into the car, because of which when Kim met with an accident, the car failed to turn left, assuming that there is a school there and there are school children here. But actually, in reality, it was a local holiday and the school wasn't functioning and there were no children found, and yet the car had actually thought that the school was functioning. So all this means that a non-reliable data was fed into the company, and this is also a breach of due diligence that the company has failed to do so. And also, the counsel for the respondents would like to stress that the company cannot simply make the offender, Kim, solely liable. So my learned counsel for the petitioners mentioned that Kim was driving the M's car in the highway with a speed of 100 kilometers, but the prosecution would like to stress on the fact that 100 kilometers was the permissible speed in the highway. So it is also clearly given in the proposition that 100 kilometers was the permissible speed, and no way Kim was over speeding on the highway, and also the car in which Kim was driving was defective. So all this enlightens us that for establishing the said accusations under Section 304A of Bharat Penal Code, it is clearly established through the fact that the accused has acted rashly or negligently, and the death of the deceased, the proximate cause of the death of the deceased was the act of the accused. So this brings into my next contention that a criminal case can be made under Section 188 of the Motor Vehicles Act. Your Lordship, in the present case, the abetment for the accused is one of the abetments by intention, wherein there is an intentional aiding by an act, or an illegal omission for doing of the offense. The accused is said to have aided the doing of an act who, either prior to or at the time of the commission of an offense, does anything in order to facilitate the commission of the act. So there have been various instances, Your Lordships, wherein Masla Incorporation and Masla Bharat have intentionally aided the M's users to use the autopilot technology. The first of such instance is what is given in paragraph point number 12 of the Moot proposition, wherein Dust had liked the tweet of him flaunting that autopilot technology could be had in up to 2 hours. That's the first instance where no action was taken by the company, and it is also clearly mentioned in the proposition that the company was secretly encouraging the M's users to use the autopilot technology in the country. And the second instance is what is given in point number 10, as I mentioned earlier, Masla Incorporation's statement that it would take action to even suspend the online account of someone who is using the autopilot technology in a country where it is not made available. But almost 70% of the people who are using the cars were hacking the autopilot technology, and yet the company seemed to have suspended none of such accounts. And finally, the council also would like to put forth that the M car seems to be vulnerable even after the geotag is being added to the car, because when the autopilot technology itself is vulnerable, and then what is the surety that the geotag will not be vulnerable? So this is one question that the state would like to impose to the council, to the learned council for the petitioners. So this brings into my end of the arguments for the third issue, that Masla Incorporation and Masla Bharat can claim immunity from prosecution under cannot claim immunity from prosecution under Bharat Penal Code and the Motor Vehicles Act. So if your lordships are satisfied with the contentions for the third issue, may I please move on to the fourth issue?
Right, proceed.
Much obliged, your lordship. The fourth issue is whether Dusk and Dandraj can claim any immunity from prosecution, given that they are just officers of Masla Incorporation and Masla Bharat respectively. So prosecution is initiated against Dusk and Dandraj, not in their personal liability, but only in their official capacity. Your lordship, I would like to argue this in various limbs. The first one being Section 1.
If it is an official capacity, you can only canvass vicarious liability.
Indeed, yes, your lordship. So only under vicarious liability we are making them personally liable, and also by
no, vicarious liability cannot be attributed so far as 304A is concerned.
Your lordship, also we are lifting the corporate veil to make Dusk and Dandraj personally.
To attract vicarious liability, mens rea should be there. There is a question of mens rea in negligence cases.
Your lordship, can you please repeat that?
The vicarious liability can be attributed only if there is some intentional act, mens rea.
Indeed, yes.
So in rash and negligence acts, how can you attribute?
Your lordship, in the present case, the intentional aiding, as I mentioned earlier, is what is the company and its CEOs secretly encouraging the users to use
Both
autopilot
can't go
technology.
together. See, 304A says 304A, one of the main ingredients is ration negligent act.
Yes, indeed, yes, Your Lordship.
So in a ration negligent act, intentional act is totally absent.
Indeed,
So
yes.
you can't say that there was intentional act on the part of the CEO and other officer bearers
But they
for the ration negligent act under section 304. Both can't go together. So
Your Lordship,
vicarious liability, how can you attribute vicarious liability to the person who is only in charge of the company, who has no direct involvement?
Your Lordship, if I may
It's a criminal
ask,
prosecution. It's a criminal prosecution. Well, for the ban under section 69A, this argument is well founded. Yes.
Your Lordship, firstly, with respect to what you said, the negligence here that is being missing, that is missed out by the accused here, is that they owed a duty of care. So we're all well aware of the ingredients of the negligence, that they should have a duty. A breach of duty must be there, and an act must be done, and damages should be caused. So here all the ingredients are satisfied, and they definitely owed a breach of duty in the present case, because of which they attracted negligence here and the criminal negligence here with respect. That is why they are being made liable under section 304A of the Ahara Penal Code. The council seeks the bench for an extension of 3 minutes to finish the contentions. 199, which clearly talks about offences by company. So if we look into the section which reads that where an offence under this act has been committed by a company, every person who at the time of the offence was committed was in charge and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. So this is a very clear statute which supports that Daskan Dandraj cannot claim any immunity from prosecution. And also, Your Lordship, with regard to the product liability that was mentioned by my learned counsel for the petitioners, firstly, as Your Lordship yourself mentioned, that it comes under a civil liability. Yet, even when they are bringing it under the civil liability, the learned counsel for petitioner himself mentioned that the manufacturer always owed a duty of care towards its buyers. And in the present case, the company, as I mentioned earlier, did not disable the autopilot technology completely. So they designed it in such a way that it was vulnerable for hacking. And even after 70% of the cars were hacked and it accessed the autopilot technology, no action or no due diligence was taken by the company. So this brings into my next contention for the test of remoteness of damage, which was again mentioned by my learned counsel for petitioners, that if the consequences of a wrongful act could be foreseen in a reasonable manner, then they are not too remote. And even this test is not satisfied in the present case, and because of which Daskan Dandraj could be prosecuted. And finally, Your Lordship, the council would like to conclude the arguments for the fourth issue by putting forward one question for the petitioners, that if, as the petitioners say, Daskan has not committed any offense, then the state is definitely questioning the reason for the extradition of Das. So as soon as the criminal proceedings were initiated against Das, the whereabouts of Das were not known, and the state would like to question that why should a man fear if he had not committed any offense? Why should he take up an extradition, and why should the council would like to end the contentions for the fourth issue by questioning this, and also by concluding that Daskan Dandraj cannot claim any immunity from prosecution, although they are just officers of the company. So if the lordships are satisfied with my arguments for the fourth issue, may I please move on to the prayer? Much obliged, Your Lordship. The council The state would like to pray before this Honorable Supreme Court that, wherefore, in the light of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this Honorable Supreme Court of Aharat to dismiss the petition filed by the petitioners as it is devoid of any merits and/or pass any other order or orders as this Honorable Court deems fit and proper in the circumstances of the given case and in the light of justice, equity, and good conscience, and thus render justice. And for this act of kindness and justice, the counsel for respondents shall be duty bound and forever pray. It was an honor arguing before this bench. Thank you so much for your valuable time.
Thank you.
Thank you, TL08. Would the judges require a moment before I invite the petitioner for rebuttals?
Right. Yes.
I now invite the petitioner for rebuttals.
Thank you. Your Lordships, with this, the petitioners would move towards the rebuttals. The ban imposed in this scenario, reasons are to be recorded in writing as provided by Section 69A of the subsection 1. No reasons were provided, nor was there any information from the government. No clarification or explanation was justified, Your Lordships. And this has been duly mentioned on the page 5 of the proposition, first paragraph as well. Your Lordships, furthermore, if the learned counsel for the respondents have covered extensively as to how such a discourse of events can be termed as an emergency situation of public interest, no committee was set up within 48 hours as mandatorized by Rule 9 of the IT laws of 2009 via the due procedure established by laws. Not only this, Your Lordships, but there was no investigations into the matter as well. Any and all arguments made by the counsel for the respondents were based on untrue allegations derived from baseless premises, Your Lordships, without any insight into the matters that truly transpired. Your Lordships, it has been extensively covered and argued by the counsel for the petitioners and my co-counsel as well that the newspaper shall not be admissible as seconded under the Evidence Act as well. No exception to this shall be followed, as also there was no affirmation to this data, nor by the government authority, neither by the company itself, Your Lordships. All the figures and the leaked internal memo allegations by the respondents stand void and inadmissible in this Supreme Court. Your Lordships, the respondents also seem to have missed out on a rather crucial fact, whereas they omitted so. They said, and I quote, M will also have an embedded 4G SIM card which will communicate to Musla servers in USA. Without first connecting to the internet, M's cannot be driven. However, Your Lordships, they purposefully misled the court and missed out the sentence in the between that clearly stated that this would be done so and accomplished by the collection of data using mobile network operators, MNOs, the networks provided by the MNOs, Your Lordships. With this, Your Lordships, the counsel for the petitioners rests its rebuttals as well.
The counsel for the respondents would like to argue for the side rebuttals. Much obliged. Your Lordship, most of the questions raised by the petitioners were answered in the arguments itself. Coming again with the same points is clearly wasting the court's time, Your Lordships. Again, with respect to the first issue, which was raised for the ban of a cool down time to review the same, Your Lordships. But if it's to be read with Section 16A, where it has been clearly mentioned that when it's satisfied on the grounds mentioned in 16A, there is no need of the review committee to be review the same. And if may also refer to rule number 14 of 16A, it has been clearly said that review committee, if satisfied with the section 16A of one of the grounds of 16A, then the ban will stand after 48 hours too. Then it is clearly then the ban is clearly now valid, Your Lordships. And with respect to, do you have any other queries? I count 6 for any other queries. Is there any queries, Your Lordships?
Okay.
Yeah.
Thank you, speakers. 3rd Surana and CUSAT School of Legal Studies Dr. A.T. Markose Memorial Technology Law Moot Court Competition 2022. Would the honorable judges wish to give their feedback?
We have a felicitation session. So can we give the feedback in that time?
Indeed, Your Lordship. Indeed, Your Lordship. I now request the participants to kindly exit the meeting.
Before exiting, the counsel for the petitioners from my side would like to actually appreciate Dr. Justice Cursor, Justice Viju, and Advocate Suri Senthil for judging us. It has actually been a very truly valuable experience, and we have, over the due course of arguing, gotten to learn a lot of new things from your end as well. And we are eternally grateful for that. This has been a very memorable experience as well. We express our gratitude for the same. Thank you, Your Lordships.
In fact, we, the judges, also enjoyed the intellectually challenging experience. You all performed well.
Thank you so much, sir.
Okay. So we'll WhatsApp it. That is the score sheet.
So before that, I request all the participants